You already have an NTA in your hand, and it may even list a hearing date. But when you open the immigration court website and enter your A number, the screen says only, "No case found." If you are still waiting for your first hearing, this can happen. A paper NTA and no record in the system yet can both be true at the same time. The most dangerous mistake is treating a blank website result as a cancellation notice. No result on the website does not mean the NTA is invalid, it does not mean the government gave up, and it does not erase a date printed on the paper. Do not guess. First understand the two gates. The first step is service. The Department of Homeland Security legally serves the NTA on you. Receiving a copy proves only that the charging document was served on you. It does not prove that DHS has already filed the NTA with the Immigration Court. The second step is DHS filing that NTA with the Immigration Court. The EOIR manual says removal proceedings begin when the government files with the court the NTA that was served on you. Having the paper in your hand and having a court case on the docket are two different events. That is why the two sides can be out of sync. After filing, the document still has to pass the first gate. EOIR staff accept it and place it in the court's case record. EOIR's electronic filing guidance for DHS uses the words accepted and docketed. For one sentence is enough. The court received it and put it on the docket. After docketing comes a possible second gate. The court sets the date and time of the first hearing. If the NTA had no date, the court schedules one after the NTA is filed. The official system displays the new hearing time only after the date is actually set. So a case record with no date yet can also happen. So one "no case found" result cannot tell you where the process is stuck. DHS may not have filed yet. After filing, EOIR still has to accept and docket it. ASIS also says that not every case or every piece of information appears. Even after a case record exists, a new hearing date appears only after the court sets it. Do not treat 7, 30 or 60 days as an official deadline. These official pages do not promise one public processing time. First rule out the simplest mistake. You must enter the A number, not a USCIS receipt number, and not another number from an ICE check-in. Document the A number is usually printed on the NTA. If the paper contains several numbers, circle the A number field by itself. Copy it one digit at a time. Do not rely on memory, and never test the system with someone else's number. If your A number has only 8 digits, add a 0 at the front to make 9 digits for the lookup. On the phone, enter only the 9 digits, not the letter A. The website also asks for country of nationality. Check each field against your documents. Do not guess from accent or memory. A wrong number, missing leading 0, or wrong nationality can all produce the wrong result. Even with perfect input, ACIS is not the complete case file. EOIR says it provides basic status information for certain cases, and that not every case or a piece of information appears. It can help you check, but it does not replace official documents sent to you or your representative by the court or the Board of Immigration Appeals. If the same number has been connected to more than one case, the website may show only the most recent one. Seeing one record does not mean you have seen the full history. Failing to see an older case does not, by itself, mean that case disappeared. What matters is the current court record and the official notices. After checking the website, call EOIR's official hotline at 1-800-898-7180. Use the same 9-digit A number. Keep the lookup date, website, screenshot, and phone result together. If the phone finds nothing, write down the time and the exact status you heard. No result from either channel means only that you still need to verify. It does not provide a legal conclusion. Now return to the NTA in your hand and check the date and place fields. If it lists a hearing date, time, and court address, treat that date as a real time-sensitive risk. Photograph the document, zoom in, and verify every word. Do not rely only on what someone else told you. Even if the website shows no result, do not assume on your own that the hearing was cancelled. If the date and time are blank, that also does not mean there is no case. EOIR explains that when an NTA does not list the first hearing date, the court sends a separate notice of hearing after scheduling. Watch for that later official notice. Do not treat a blank field as a closed case stamp. The most important point is this: the website is not a cancellation notice. If the NTA, a later hearing notice, or a court document forwarded by your lawyer lists a date, do not miss it because of one no case found result. If the date is close, has already passed, or conflicts with another source, verify it immediately. This is not hypothetical. EOIR has an official notice called "No Case Currently Pending" for a person who comes to court as instructed by an NTA when DHS has not yet filed the case. The notice is also clear that only DHS can file the NTA. You cannot start the case for the government. First, save the original documents. Clearly photograph every page of the NTA, the service information on the back, every paper that arrived with it, and the envelope. Store a copy somewhere that will not disappear with your phone. Keep the originals separately, and make a complete backup before giving anyone a copy. Do not save only the date, and do not hand originals to anyone who gives you no receipt. Second, make a verification log. Write down the 9-digit and number, whether the NTA has a date, which court is listed, when you check the website, and when you called the hotline. Record whether each call connected and the exact status you heard. Put a time on every result. If something changes later, you will know which information changed and on what date. Third, if the paper already has a date or two, sources show different dates. Contact the immigration court listed on the notice and your lawyer. Explain which documents you have, your A number, and the conflict, and ask them to verify the current record. If the date is close, start contacting them that day. Do not wait for the website to change by itself, and do not choose a date based on a quick social media reply. Fourth, do not mail the NTA to the immigration court yourself just to make the system move faster. EOIR's official notice is clear. Only DHS can file the NTA. An individual cannot start the case for the government. Whether to press the government to file may affect case strategy, so let a qualified representative assess that first. Fifth, set a repeating reminder. Keep checking the website and hotline with the same 9-digit number, and watch your mail, messages from your lawyer, and court documents. Use a calendar instead of memory, and turn every check into a written record. While waiting, make sure the immigration court can reach you at the correct contact information. Separate address duties after a move still follow the rules that apply to you. There is no magic checking frequency. The point is to keep checking, keep records, and verify any new date immediately. Here is another high-risk mistake. One no case found result cannot decide where you file Form I-589. EOIR's FAQ says only that electronic filing through respondent access becomes available after DHS files the NTA and EOIR accepts it. You must promptly verify the actual filing location and applicable deadline using the current I-589 instructions and your own procedural status. Do not miss a deadline while waiting for the system to update. Reduce this to 3 simple situations. First, the NTA has no date, and neither the website nor the hotline finds a case. You cannot say the case was cancelled. Save the documents, confirm the number, keep checking, and watch for later notices. If the filing location, deadline, or case strategy is uncertain, find a qualified representative promptly. Do not let a group chat decide for you. Second, the NTA lists a date, but the system finds nothing. Do not treat the blank website as permission to stay home. Immediately contact the court listed on the notice and ask it to verify the current record. Also contact a qualified representative about the next step. Until you receive an official EOIR notice, rescheduling or cancelling the hearing, do not treat the date on the paper as cancelled. Save every contact attempt and every response. Third, the dates on the NTA website, phone system, or later notice conflict. Do not choose the latest, nearest, or most convenient one yourself. Put every document and lookup record together. First ask the court handling the case to verify the current schedule. Then ask a qualified representative how to act. Official notices issued by the court are the official source of case status. Record the contact date, the person who answered, and the response. When you need advice about your individual case, look first for a licensed attorney or a fully accredited representative working through an EOIR-recognized organization. A notario, immigration consultant, or visa consultant cannot represent you in immigration court. Check credentials before paying. If money is limited, start with EOIR's pro bono list. In the end, remember only 2 gates. First, DHS files and EOIR accepts and dockets the document. Only then can a case record appear. Second, the court schedules the hearing. Only then can a new hearing date appear. ASIUS reflects only part of the result. Having the NTA does not prove that both later steps are complete. Protect yourself with 3 anchors. Every page of the NTA in your hand, your dated website and hotline records, and the official notices issued by the court. When the system is blank, do not guess, lose your documents, or become unreachable. Save, contact. That helps prevent a temporary synchronization gap from turning into an avoidable missed hearing. Track USCIS trends, judge grant rates, court jurisdictions, and anonymous case timelines with AsylumTracker.